officers. Sections 447 to 454 of the Companies Act 2013 are the enforcement engine. They define fraud, create the penalty framework, establish adjudicating officers, and constitute special courts. The Companies Act does not just set rules euros, it punishes those who break them. This is the complete guide to the enforcement machinery. Section 447 defines fraud. It covers any act, omission, concealment, or abuse of position with intent to deceive, gain undue advantage, or injure the company, its shareholders, creditors, or any other person. The definition is deliberately broad. Fraud involves an element of intent euros, it is not negligence. But if intent is present, almost any wrongful act can be fraud. Penalty for fraud: imprisonment from 6 months to 10 years euros, and a fine of at least the amount involved, up to 3 times the amount. If the fraud involves public interest, the minimum imprisonment is 3 years. The penalty is severe by design. Fraud is the most serious offense under the Companies Act. Section 454 establishes adjudicating officers. The central government appoints officers who can impose penalties for defaults that do not amount to fraud euros, procedural violations, filing defaults, governance lapses. The officer gives the defaulter a hearing, examines the evidence, and passes a reasoned order. This is the non-criminal enforcement track. Special courts under Section 435 try offenses punishable with imprisonment of 2 years or more. These courts follow summary trial procedures for faster disposal. Company law cases should not take a decade to resolve. Special courts are the Act's answer to judicial delay, dedicated judges, dedicated timelines, dedicated enforcement. The Companies Act does not just tell you what to do, it tells you what happens if you do not. Fraud, penalty, adjudication, special courts, the enforcement apparatus is complete and severe. Comply with the law or face the consequences. There is no third option. Thank you for watching.